Okay. So in the last class, someone asked me to share some important articles of the Constitution of India related to governor. So here are some important articles. Article 153. There are many articles, but you have to remember related to governor these articles. Article 153, that there shall be governors of states. Okay. Article 155 is related to appointment of the governor. Article 160, discharge of the functions of governor, means what are the powers and functions, which we have already discussed in the last class. Yes. Article 161, power of the governor to grant pardon, just like the president enjoys the power to grant pardon. Okay. The governor, under his jurisdiction, he also enjoys this power to a certain limit. Please remember this. This article is very important. Article 161. You will also have to remember about the article of the president, his power to grant pardon. Okay. And Article 164 are the provisions as to ministers like appointments, terms, salaries, and others, which I have said that, it is the governor who appoints, who decides about the appointments, about the term, salaries, and others, but on the recommendation of chief minister. Okay. But it is he who performs these things on the recommendation of the chief minister. And regarding the chief minister, here are the two articles which you need to remember. Um, these things are important for your general studies paper also, because these are general knowledge. Yeah. Like under which article governor has the power to grant pardon. Okay. So related to chief minister, you have to remember these two articles. Article 163, there shall be a council of ministers to aid and advise the governor. Aid and advise the governor means what? That the activities of the council of ministers needs to be supervised by the governor. Yes, every information regarding the state administration has to be furnished to the governor. Okay. And this thing is done by, I think you all know, by the CM. Yes. Article 167, duties of chief minister as respects the furnishing of information to governor. So these two articles are important regarding related to the chief minister of a state. But today we will discuss a fresh new topic, that is High Court. Okay, you see, organization of High Court, huh? The Constitution of India envisages the same pattern of government in the states as that for the center. That is a parliamentary system, isn't it? Which I have already told you. And যিটো তোমালোকক মই আগৰ ক্লাছতো কৈছিলো যে পাৰ্লিয়ামেন্টৰ ক্ষেত্ৰত তোমাৰ যেনেকে ষ্টেট লেজিসলেচাৰ, পাৰ্লিয়ামেন্টখন লেজিসলেচাৰ, isn't it? তো তেনেকে ষ্টেট লেজিসলেচাৰো থাকে। তো তাত কনজিষ্ট কেনেকে হয়, means it is composed of যেনেকে two houses আৰু president. Yes, তেনেকে ষ্টেটৰ ক্ষেত্ৰত two houses and the governor. তো এই state administrationৰ ক্ষেত্ৰত এতিয়া সেইটো আমি পঢ়িলো legislature. Yes. কিন্তু এতিয়া আমি সেই state administrationer, now we are going to discuss about courts, about the judiciary. So we all know that our judiciary is independent. হয়নে? গতিকে ইয়াতে কোনো political members as member হিচাপে কোনো judiciary নাথাকে। ঠিক আছে? Supreme Court is the supreme judiciary, isn't it? It is the independent court. আৰু সেই ঠিক তেনেধৰণে তোমাৰ চেণ্টাৰৰ কথা পঢ়োতে যেনেকে সুপ্ৰিম কোৰ্টৰ কথা পঢ়িব লাগিব তো ষ্টেট এডমিনিষ্ট্ৰেশ্যনৰ জুডিচিয়াৰীটো যেতিয়া পঢ়িব যাবা then you will have to know about the high court. Okay. So in the Indian single integrated judicial system, the High Court operates below the Supreme Court. ठीक है? But above the subordinate courts. Okay, subordinate courts, I think you all know the tribunals, the district courts, isn't it? So the judiciary, in a state consists of a high court and a hierarchy of subordinate courts. বুজি পাইছানে যি ধৰণে সেই legislature পঢ়োতে আমি গম পাইছিলো that the state legislature consists of the two houses, that is legislative council and legislative assembly and the governor. ঠিক তেনেকে state administration পঢ়িব যাওঁতে যেতিয়া আমি judiciary কথা পঢ়িব যাম, we should know that the judiciary in a state consists of a high court and a hierarchy of subordinate courts. ঠিক আছে যেনেকে hierarchy of subordinate court means the district courts and the tribunals are not above the high court. Okay, and the high court also operates below the Supreme Court. Okay. The High Court, occupies the top position in the judicial administration of a state. Okay. So the High Court consists of a Chief Justice and such other judges. But you know what? The Constitution does not specify the strength of a High Court. মানে High Court at kimanjon judges থাকিব লাগিব, including the Chief Justice. That particular strength, that particular number has not been defined by the Constitution. You can't say that okay, there will be 31 judges, including the including the Chief Justice, there will be 31 judges or 30 judges in High Court. Okay, there is no, definite strength of a High Court that is defined by the Constitution. Constitution has not specified the strength of a High Court. And the Constitution leaves it to the discretion of the president. Discretion of the president means it will be decided by the president that how many that the High Courts will consist of how many members. Okay, the Constitution leaves it to the discretion of the president, and accordingly the president determines the strength of a High Court from time to time. Okay, from time to time, depending upon its workload, the president will decide. So that's why the Constitution has not specified any particular strength. Okay, গতিকে এইটো ভালকে চাবা because question may come কাৰণ কি Supreme Courtৰ কেইজন judge থাকিব লাগে বুলি question আহিব পাৰে বা High Courtৰ কেইজন judge থাকিব লাগে বুলি question আহিব পাৰে. You in your options maybe there will be given 31 judges, 30 judges, or not specified. So obviously the answer will be not specified. Okay, not specified by the Constitution. And the Chief Justice is appointed by the President of India. Every High Court has the Chief Justice. Okay, and the Chief Justice is appointed by the President of India after consultation with the CJI. CJI means Chief Justice of India. Okay, Supreme Court or Chief Justice the Chief Justice of India, isn't it? So after consulting with the Chief Justice of India and the governor of the state concerned, the Chief Justice of that High Court is appointed. ঠিক আছে যে সব High Courts or Chief Justice থাকে, you all know, I think. আৰু সেইবিলাকক Chief Justice কেইজনক appoint কৰা হয়, the appointment is done by the President, but after consultation with the Chief Justice of India. আৰু Chief Justice of India এজনে থাকে, ঠিক আছে? Chief Justice of India এজনে থাকে, কিন্তু Chief Justice of High Court প্ৰত্যেকটো High Courtৰে Chief Justice বেলেগ থাকে. But Chief Justice of India বুলি ক'লে I think you all know. And the governor of the state concerned. এওঁলোকৰ লগত কনসালটেশনৰ পিছতহে প্ৰেসিডেন্টে কাক এপইন্ট কৰিব, he decides. Appointment of judges are made by the president. So this is the organization of the High Court. যে High Courtত কেইজন জাজ থাকে, কিমান Chief Justice কোনে এপইন্ট কৰে বা other judges কোনে এপইন্ট কৰে. Okay, সেই কথাখিনি এইখিনি organization of High Court. Then qualification of judges. He should be a citizen of India. He should have held a judicial office in the territory of India for 10 years ঠিক আছে ইয়াতে যেনেকে আগতে আমি পাইছিলো যে লোকসভাৰ মেম্বাৰ বা ৰাজ্যসভাৰ মেম্বাৰ হ'বলৈ কিমান এজ লাগে বা গভৰ্ণৰ হ'বলৈ কাৰণে CM হ'বলৈ কাৰণে যেটো আমি লাষ্ট ক্লাছত ডিসকাস কৰিছিলো যে 35 years isn't it so yate tenekwa kono particular age dia nai but he should have held a judicial office in the territory of India for 10 years means to become a judge of high court he should have experience of 10 years okay 10 years in judicial office ba 10 years judi he has advocacy in high court for 10 years then also he is eligible for to become a judge of the high court ঠিক আছে কোনোবা মানে কোৰ্টৰ যদি সাবঅৰ্ডিনেট কোৰ্টছ বিলাকৰ sorry subordinate নহয় high courtৰে যদি তেওঁ advocate হৈছে for 10 years if he has the experience of 10 years of experience of advocacy in high court then he is eligible to become a judge of the high court okay so these three are the conditions that you need to remember now you see the tenure of judges he holds office until he attains the age of 62 years. He can resign his office by writing to the president. Yate, you have to remember this, that 62 years, because kunu jetia Indian polity papers, paper khonar aru beleg topics poriba, tate dekha paba the Supreme Court or hog, ba High Court or hog, then kisuman post or tenure to up to 62 years thake kisumanat ba up to 65 years thake so you don't get confused you have to remember this that the judges of high court hold office until they attain the age of 62 years okay 62 আৰু 65 ৰ ভিতৰতে maximum খিনি আছে গতিকে হে দুটাই ভালকে মনত ৰাখিবা আৰু then he can resign his office by writing to the president. If he wants to resign his office, if he wants to give resignation, then he will have to write to the president. Education, I think agote ebar ahise je if the judges of high court wants to resign from their office, then they have to approach or write to the president or to the prime minister. It was to confusion kya ahise, so you need to remember. And he can be removed from his office by the president. Okay, judges can also be removed from their office by the president if the parliament recommends. ঠিক আছে he vacates his office when he is appointed as a judge of the Supreme Court. And another condition to it way, the judges can vacate their office if they are appointed as judge of the Supreme Court. Supreme Court or jodi judge hisabe appoint korise, then he will definitely have to vacate his office from the High Court. Okay. And one more thing I need to tell you that regarding the removal of the judges, okay, regarding the removal of the judges, you know, no doubt I have said that a judge of a high court can be removed from his office by an order of the president. Means the president can remove the judges, but the president can issue the removal order only after an address by the parliament. Okay, after an address by the parliament has been presented to him in the same session for such removal. And the address must be supported by a special majority of each house of parliament. বুজি পাইছে তাৰ মানে প্ৰেসিডেন্টে বিচাৰিলে তেওঁক জাজজনক মুভ কৰাৰ মানে কি আৰু পাৱাৰটো নাই no doubt the judges can be removed by the president কিন্তু remove korute that address must be supported by a special majority of each house of the parliament tar mane each house of the parliament they will have to give their consent. Okay, they will have to give their consent. That is, a majority of the total membership of that house. and a majority of not less than 2/3 of the members of that house present and voting. তাৰমানে এই বস্তুটো পাৰ্লিয়ামেন্টৰ আগত that is before the two houses of parliament এইটো বস্তু যদি প্ৰেজেন্ট কৰিব তেতিয়া not less than 2/3 of the members of that house present and voting. সেই বস্তুটো 2/3 majority of each house এইটো support কৰিব লাগিব যে তেওঁক remove কৰিবলগীয়া হৈছে ঠিক আছে তেতিয়াহে and then after that the president can remove the judges and the grounds of removal are two proved misbehavior or incapacity বুজি পাইছেনে যে প্ৰেসিডেন্ট জনে যেতিয়াই বিচাৰিলে তেতিয়াই তেওঁক অটৰাই দিবলৈ নোৱাৰে অনলি দুটা গ্ৰাউণ্ড আছে ওৱান হৈছে proved misbehavior যদি কিবা কাৰণত the judges of the high court are seen to have misbehaved or if the president has seen any of the judges as incapable okay যদি কিবা ক্ষেত্ৰত incapable দেখিছে তেনেহলে এই দুটা গ্ৰাউণ্ডত যেতিয়া অটৰাব খুজিব if on the basis of these two grounds the president wants to remove the judges of the high court then the president can do so but after getting 2/3 of 2/3 of the members of each house of the parliament present and voting only after voting okay so a judge of a high court can be removed in the same manner and on the same grounds as judge of the supreme court ঠিক আছে গটিকে এই যেটো মই প্ৰসেসটো কলো এই প্ৰসেসটো হাই কোৰ্টত যেনেকুৱা তেনেকে সুপ্ৰিম কোৰ্টতো হে একে গটিকে সুপ্ৰিম কোৰ্টৰো জাজক অটৰাব যাওঁতে এটো এনেকে আহিব পাৰে it's not a big deal যে the president can remove the judges of the supreme court but after getting approval মানে কিমান votes পোৱাৰ পিছতহে এই কামটো হ'ব পাৰে 2/3 majority 1/3 majority of each house বা of both the houses okay এই ধৰণে আহিব পাৰে so you have to remember the 2/3 of the members of the house present and voting যদি 2/3 members পাই যায় voting পাই যায় এইটো কাম কৰিবলৈ কাৰণে then that judge can be removed okay see like the Supreme Court, the High Court has been vested with quite extensive and effective powers. It is the highest court of appeal in the state. The High Court is the highest court of appeal in the state. And it is the protector of the fundamental rights of the citizens. Yes. And it is vested with the power to interpret the constitution. Besides, it has supervisory and consultative roles also, isn't it? Just like the Supreme Court. গতিকে Supreme Court or যেনে ধৰণৰ jurisdiction আছে, powers, jurisdiction and powers আছে, তো ঠিক তেনেদৰে High Court আছে. But you have to remember that the subordinate courts work under the High Court and the High Courts work under below the Supreme Court. ঠিক আছে কিন্তু more or less যি ধৰণে সুপ্ৰিম কোৰ্টৰ আছে অৰিজিনেল জুৰিসডিকশন এপেলেট জুৰিসডিকশন সুপাৰভাইজৰি জুৰিসডিকশন তো ঠিক তেনেদৰে হাই কোৰ্টৰ কিছু ক্ষেত্ৰত আছে ঠিক আছে গতিকে কোৱেশ্চনত যেতিয়া civil service or question appear koribo to tetia directly write down the powers and functions of high court boli nahibo pare okay the question may come in a critical manner but the answer will be the same question eneke ahibo pare je discuss about the jurisdiction of high court ঠিক আছে so jurisdiction of high court jaunte he high court or more or less he powers and functions khinir kothai likha jabo the original jurisdiction of how the high court acts or what are the activities okay what are the activities that fall under this jurisdiction that the high court performs okay so kotha khini ekhini is that when you will be say that discuss about the jurisdiction of high court that means you were asked to write about the powers and functions under the jurisdiction of the high court the original jurisdiction of kenukwa mane functions ase writ jurisdiction of kenukwa functions ase high court or appellate jurisdiction of kenukwa functions ase so he ekekhini kothai see the Constitution does not contain detailed provisions with regard to the jurisdiction and powers of a high court. You see, it only lays down that the jurisdiction and powers of a high court are to be the same as immediately before the commencement of the Constitution. But there is one addition. That is, the Constitution gives the High Court jurisdiction over revenue matters, which it did not enjoy in the pre-Constitution era. And Tarupuri, the Constitution also confers some more additional powers on a High Court, like writ jurisdiction, power of superintendence, consultative power, and so on. Moreover, it empowers the Parliament and the state legislature to change the jurisdiction and powers of a High Court. I hope you are understanding that just like it empowers the Parliament and the state legislature. That means the Constitution has not laid down, contained detailed provisions, regarding the jurisdiction and powers of a high court, but still it has empowered the Parliament and the state legislature to change the jurisdiction and powers of a high court. High Courter কিছুমান যদি powers and jurisdiction change কৰিব লগা হয়, then the Parliament and the state legislature can do so, because they are empowered by the Constitution to sometimes to change the jurisdiction and powers of a high court. ঠিক আছে? So at present, a high court enjoys this following jurisdiction and powers. Okay, number one is original jurisdiction. Okay, original here these are some of the functions that fall under original jurisdiction, like matters of admiralty, will, marriage, disputes relating to revenue matters, and so on. It means the power of a high court to hear disputes in the first instance. Okay, original jurisdiction money the power of a high court to hear disputes in the first instance, not by way of appeal. Okay, so in this case, it extends to the matters of admiralty. Okay, matters of will, matters of marriage, matters of divorce, company laws, contempt of court, and it also hear disputes relating to the election of members of Parliament and state legislatures. Okay, regarding revenue matter, or an act ordered or done in revenue collection, and enforcement of fundamental rights of citizens, and cases ordered to be transferred from a subordinate court involving the interpretation of the Constitution to its own file. Okay, so these cases, these things fall under original jurisdiction. And কেতিয়াবা এনেকুৱাকে আহিছে একবাৰ যে যিবোৰ matter, the matters which I have mentioned, okay, so সেই matters বোৰ দি দিয়ে যে the matter of, suppose the matter of marriage or the matter of company law. Okay, the matter of company law falls under which of the following jurisdiction of High Court? Okay, so then you will have to answer, that is the matter of company law falls under original jurisdiction. But the matter of admiralty, but matter of will মানে তো বুজি পাইছে, এখন agreement, will নিজৰ মৰ্জি মতে কৰা এখন agreement. So this matter of will, the matter to make will, so the matter to make will falls under which of the following jurisdiction of High Court? High Court or kuntu jurisdiction not a matter of will to pore ba matter of will to pore ba marriage to pore. So jetia powers and functions porha jaba ba High Court or jurisdiction khini porha jay, to jetia original jurisdiction ki ase ba writ jurisdiction boli koa loge loge we all know that writ jurisdiction ki ase habeas corpus, mandamus, certiorari, prohibition, এখানে generally মানুহৰ মনত থাকে যেহেতু writ বুলি কোৱা লগে লগে। Okay, কাৰণ কি আমাৰ এইকিটা 5 writs are there, which we all know. And why these writs are given, we all know this also, because যিটো আমাৰ right to constitutional remedies ৰ ক্ষেত্ৰত এই 5টা writ পৰে, হয় নহয়? গতিকে writ jurisdiction বুলি কোৱাৰ লগে লগে কি আহিব, we more or less আমি জানোৱে আৰু, কিন্তু এই অৰিজিনেল jurisdiction বা appellate jurisdiction, এই jurisdiction কিটা পঢ়োতে তাৰ মানে সেই matters কিটা অলপ ভালকে focus কৰা, it is important to focus on the matters, because questions আগতে তেনেকে আহিছে যে matters of marriage বা disputes relating to revenue matters, যে এই বস্তুটো high court ৰ কোনটো jurisdiction ত পৰে, ঠিক আছে? And then number 2, writ jurisdiction. So Article 226 of the Constitution empowers the High Court to issue writs. Why not? One more thing, this Article 226, try to note it down, that writ jurisdiction as Article 226 of the Constitution empowers the High Court to issue writs, and Article 32 of the Constitution empowers the Supreme Court to issue writs. Try to note it down. The High Court can issue writs under which article? That is Article 226. And the Supreme Court can issue writs under Article 32 of the Constitution. Okay, try to remember these 2 articles. Because মই compare কৰি কাৰণে পঢ়াইছো, কাৰণ কি jurisdiction বোৰ, powers and functions বোৰ more or less Supreme Courtৰ মানে চেণ্টাৰৰ যেতিয়া আমি বস্তু পঢ়া যায়, চেণ্টাৰৰ বস্তু আৰু ষ্টেটৰ বস্তু পঢ়োতে more or less একেই থাকে। যি ধৰণে মই পাৰ্লিমেণ্টৰ কথা কওঁতে গম পোৱা গৈছে ন, যে 2টা হাউচ আৰু লগত কোন থাকে? প্ৰেচিডেণ্ট। So 2 houses of the parliament and the president consist the parliament. Yes, তো ঠিক তেনেদৰে state legislature ক্ষেত্ৰতে মই কৈছো যে 2টা হাউচ থাকে আৰু লগত কোন থাকে? গভৰ্ণৰ থাকে। আৰু প্ৰেচিডেণ্টৰ powers and functions বোৰ more or less গভৰ্ণৰৰ লগতো একেই, similar, কাৰণ কি প্ৰেচিডেণ্টজন যেনেকে head of the state, তো ঠিক তেনেকে গভৰ্ণৰজন head of the state administration, isn't it? গতিকে more or less একে থাকিব। গতিকে compare কৰি পঢ়িলে it will be fruitful for you to remember things in a simple way. Okay, গতিকে যেতিয়া writ jurisdiction পঢ়া যাব, তেতিয়া আৰ্টিকেলটো মনত ৰাখিব লাগিব, 226 of the Constitution empowers the High Court to issue writs, and Article 32 of the Constitution empowers the Supreme Court to issue writs. And what are these writs? You all know that habeas corpus, mandamus, certiorari, prohibition, and quo warranto, isn't it? For the enforcement of the fundamental rights of citizens. এই writs কিটা কিহৰ কাৰণে দিয়া গৈছে? Because to enforce the fundamental rights of the citizens, and for any other purpose. আৰু any other purpose বুলি কোৱাৰ লগে লগে কি mean হয় যে for any other purpose.
Just a minute, hold on please. Nimita, share the screen once again.
Is it visible?
No, not yet. Yeah, do it again.
Is it visible now?
No, ma'am. Just hold on, aspirants. I think ma'am is having some network issue. Okay.
Yes, we can see. Your video is on.
Okay.
Share
Okay.
the screen.
Now?
Yes, share the screen.
Okay. Is it visible now?
No,
I'm sharing.
no.
No?
No, ma'am, it's still not visible.
I don't know, sir, all of a sudden what has happened.
Ma'am, do one thing, rejoin again.
No,
Let's
no,
try.
no need. No need to rejoin.
1 minute, huh?
Because you're being co-host.
Now. Now?
Yes. Yes.
Is it visible now?
Yes. Yes. Please
Yes, ma'am,
proceed.
visible.
Yeah. Sorry for the disturbance, students. Please proceed.
Okay. Okay, we were here. Read jurisdiction, huh? And you know the phrase that is for any other purpose, which I have said right now, that this issue that these writs are are issued by the High Court under Article 220 of the Constitution to enforce fundamental rights of the citizens and for any other purpose. So here, any other purpose refers to the enforcement of an ordinary legal right also. Okay. যিটো এই মানে writs দিয়া যায় যে habeas corpus mandamus certiorari prohibition quo warranto, this the writs are given to issue by the courts, you know, basically to enforce the fundamental rights, because we all know যে আমাৰ যিকেইটা fundamental rights আছে সেই fundamental rights কেইটা যদি somehow if the fundamental rights of the citizens get violated, then through the last fundamental right, it is right to constitutional remedies, isn't it? Hey, right to I think you all know that a writs kita kuntu fundamental right ot ase, it is in the last, that is the right to constitutional remedies, হয় নহয়? গতিকে এই সেই right to constitutional remediesতে এইকেইটা writs দিয়া হৈছে যাতে যদি সেই পাঁচটা fundamental right যদি violate কৰা হৈছে, if somebody has been deprived of enjoying the fundamental rights, তেনেহলে through the right to constitutional remedy সেই person জনে তোমাৰ through the courts, through judiciary যদি violate হৈছে তেনেহলে enforce কৰিবলৈ কাৰণে এই writs কিটাৰ জৰিয়তে enforce কৰিবলৈ পাৰে if someone's fundamental rights have been violated. আৰু তাৰ উপৰি এই যিকেইটা writsৰ কথা কৈছে, এই writs কিটা any other purpose মানে কি mean কৰিছে যে refers to the enforcement of an ordinary legal right also. I think you all know that our besides the fundamental rights, certain rights have been categorized as legal rights, isn't it? So for the enforcement of the fundamental right as well as the enforcement of the ordinary legal right also, these writs can be issued by the High Court. Okay, by the High Court as well as the Supreme Court. So the High Court can issue writs to any person. Okay, any person, any authority and government, not only within its territorial jurisdiction, but also outside its territorial jurisdiction. Okay, if the cause of action arises within its territorial jurisdiction. তাৰ মানে চাওক, যেটো High Courtৰ কথা পঢ়োতে আমি এইটো গম পাইছো যে High Court Supreme Courtৰ যিখিনি powers and functions সেইখিনি all over India. কিন্তু High Courtৰ ক্ষেত্ৰত নিজৰ jurisdictionৰ আন্ডাৰতহে তেওঁ High Court কিটাই কাম কৰিব, হয় নহয়? যে because states have their own High Courts. কিন্তু এই writ jurisdictionৰ ক্ষেত্ৰত কি হয় যে the High Courts can issue writs not only within its territorial jurisdiction. Because কোনোবা এজন particular মানুহ বা কোনোবা এটা authority কিবা কাৰণত যেতিয়া right to violate হয়, সেইটো সেই High Court মানে High Court এইকাৰণে এই writs কিটা issue কৰিব পাৰে নিজৰ territorial jurisdictionৰ আন্ডাৰত নহলেও, because সেই কেছটো, because the cause of action may rise within its territorial jurisdiction of মানে ভিতৰত সেই কেছটো হ'ব পাৰে বা বাহিৰত হ'ব পাৰে কিন্তু মানুহজন বিলং কৰে হেয়াত suppose মানুহজনৰ violate hoise apuni it's just an example that any of your fundamental right has got violated when you were outside Assam, isn't it? The case has happened outside the territorial jurisdiction of the High Court of Assam, hoy noy kintu apuni he goi pilai he High Court approach koribo pare ohomot ahi pilayo. I hope you are getting the point je kiba ta karon jodi kiba right violate hoy ohomor bahirote hok ba north easter bahirote jeniba hol India kuno eta jagat kintu he bostu to ahi pilai apuni ako ohomot ahi pilai through the High Court of this states of the northeast states he bostu to ako approach koribo para High Court to approach koribo para jai to issue the writs for the enforcement of his fundamental right or his ordinary legal right. The High Court can issue writs to any person, authority, and government, not only within its territorial jurisdiction, but also outside its territorial jurisdiction. Okay, and the writ jurisdiction of the High Court, that is under Article 226, is not exclusive. This is not exclusive, but concurrent with the writ jurisdiction of the Supreme Court, which is under Article 32. It means that the fundamental rights of a citizen are violated. The aggrieved party has the option. The aggrieved party has the option of moving either the High Court or the Supreme Court directly. And the jurisdiction, writ jurisdiction of the High Court is wider than that of the Supreme Court. And this is because the Supreme Court can issue writs only for the enforcement of fundamental rights and not for any other purpose. That is, it does not extend to a case where the breach of an ordinary legal right is alleged. I hope you were getting the point. It was just moi kolu je any other purpose. Any other purpose boli konte moi ki kolu je it refers to the enforcement of ordinary legal right also. Kintu Supreme Court or khetrot ki hoy? Supreme Court can issue these writs only for the enforcement of fundamental rights. Jetia fundamental rights kabar violate hoy and tetia Supreme Court approach koribo jai tetia Supreme Court a writs kita issue kore under Article 32 for the enforcement of fundamental right. Kintu onno kuno karonote the Supreme Court does not issue these writs except the enforcement of enforcement for the fundamental right. Kintu High Court or khetrot ki High Court or a jurisdiction, the jurisdiction is wider than that of the Supreme Court because High Court it issued this writs under Article 226 for the enforcement of fundamental right also, as well as for the enforcement of an ordinary legal right also. And then let's move to appellate jurisdiction. So appellate jurisdiction, a High Court is primarily a court of appeal, isn't it? It is a court of appeal. It hears appeals against judgments of subordinate courts functioning in its territorial jurisdiction. Appellate court bali kihor karone koa hoise, this is primarily a court of appeal because jetia when the aggrieved party when the party is not satisfied with the judgment of the subordinate courts, that is the district courts, tribunals, isn't it? When the party is not satisfied, then basically it approaches the High Court, isn't it? So that is why the High Court is primarily said to be a court of appeal because it hears appeals against the judgments. Okay, against the judgments of subordinate courts that function in its territorial jurisdiction. So it has appellate jurisdiction in both civil and criminal matters. Hence, the appellate jurisdiction of a High Court is wider than its original jurisdiction because I have told you that under original jurisdiction, there are some particular matters that the High Court deals, which fall under original jurisdiction. Kintu appellate jurisdiction is wider than original jurisdiction of High Court. Why? Jitu moi just kolu je kunubai High Court directly approach koriba pare. Pare means ki korise, that is a different matter. Kintu jetia in general ki hoy je subordinate courts bilake manuhe generally approach kore, district court, tribunals, isn't it? গতিকে generally যিখন districtৰ মানুহতে obviously the nearest যি আছে হে approach কৰিব কিন্তু যেতিয়া when the party is not satisfied with the judgment of the subordinate courts, then they appeal to the High Court, isn't it? গতিকে তেতিয়া সেই ক্ষেত্ৰত কি হয় হাই কোৰ্টলে যিবোৰ নিজা original jurisdiction যিবোৰ matters আছে, the High Court has to deal with the matters also which fall under original jurisdiction. But apart from the original jurisdiction, the High Court also have to hear about the cases, about the judgments given by the subordinate courts, because the people, if they're dissatisfied with the judgments of the subordinate courts, then they appeal to the High Court also. Okay, so that is why the appellate jurisdiction is wider than original jurisdiction. And the appellate jurisdiction of a High Court, consists of both criminal, civil, and criminal matters. Civil appellate jurisdiction of a High Court is first, appeals from the orders and judgments of the district courts. Okay, additional district courts and other subordinate courts directly to the High Court. And secondly, it appeals from the orders and judgment of the district court or other subordinate courts lie to the High Court in the cases involving questions of law only. আৰু তেনেকে civil case বিলাকৰ বাহিৰে, apart from the civil cases regarding the criminal matters, the criminal appellate jurisdiction of a High Court is such that it gets appeals from the judgments of session court and additional session courts. Okay, so the High Court can hear cases regarding both civil and criminal matters under appellate jurisdiction. The fourth one is supervisory jurisdiction. You see, a High Court has the power. Okay, a High Court has the power of superintendence over all courts and tribunals functioning in its territorial jurisdiction. ঠিক আছে, but listen, one more thing. যেটো supervisory function বুলি কৈছো, এই supervisory function to High Courter আছে, but over whom? Over the subordinate courts and tribunals in the functioning in the territorial jurisdiction. গতিকে এই supervisory jurisdiction to Supreme Courter ক্ষেত্ৰত থাকোতে তাত কিন্তু High Court সোমাব, যিহেতু the High Court works below the Supreme Court, হয় নহয়? কিন্তু High Courter supervisory jurisdiction বুলি কওঁতে তেতিয়া High Court has the power of superintendence. Superintendence means to supervise, isn't it? To supervise all the courts, all the subordinate courts and tribunals. গতিকে High Courter ক্ষেত্ৰত সেই subordinate courts আৰু tribunalsৰ কথাবোৰ আহে যাক supervise কৰে High Court. ঠিক আছে, but except military court tribunals, I think you all know that the military section, they have their own military courts. গতিকে সেই military courts or ক্ষেত্ৰত the High Court does not enjoy this supervisory power over the military courts. Okay, except the military courts, High Court has the power of superintendence over all courts and tribunals functioning in its territorial jurisdiction. Keep in mind, except the military courts or military tribunals. So therefore it may call for return from them. তাৰমানে কেতিয়াবা এনেকুৱা হয় যে subordinate court a case is going on, but that particular court is unable to solve the issue, to solve the dispute in a short duration of time, and then the High Court can also call for return from them. তাৰমানে generally subordinate courter পৰা High Court appeal কৰা হয় যেতিয়া after getting the judgment and when the party becomes dissatisfied with the judgment. কিন্তু কেতিয়াবা কিছুমান case generally governmentor লগত related থকা case, when some cases are are still pending in the subordinate courts, so those cases may be asked by the High Court also. Case to উঠাই পেলাই directly High Courtত দিবলৈ কাৰণেও the High Court can ask to do so. Okay, so supervisory jurisdiction কি কৰে, make and issue general rules and prescribe forms for regulating the practice and proceedings of them. ঠিক আছে, prescribe forms in which books, entries and accounts are to be kept by them, settle the fees payable to the sheriff, clerks, officers, legal practitioners. So এইবোৰ ক্ষেত্ৰত এইবোৰ supervise কৰা হয়, supervised by the High Courts. Okay, and this power of superintendence of a High Court is very broad. Okay, because it extends to all courts. Jitu superintendent's jurisdiction to kotha koiso, it is very very broad. Okay, because it extends to all courts and tribunals, whether they are subject to the appellate jurisdiction of the high court or not. Tamane appellate jurisdiction moi ki bujaisilo, moi ki koisilo je it hears against the judgments of subordinate courts. Generally subordinate courts a judgment to diar pisot jodi dissatisfy hoy tetia he particular party to high court approach kore. Kintu supervisory jurisdiction to aru besti brother e karone brother because nijor already the high court has its original jurisdiction where there are some matters. Secondly, appellate jurisdiction at ki hoy jitu the high court has to hear appeals. ঠিক আছে, supervisory jurisdiction কি হয় কেতিয়াবা হাই কোর্টে তার মানে ইয়াতে যিকোনো এটা পার্টিয়ে মানুহে হাই কোর্টক এপ্ৰোচ নকৰাকেও হাই কোৰ্টে নিজা supervisory jurisdictional আন্ডাৰত যিকোনো এটা কেস সাবঅৰ্ডিনেট কোৰ্টত যেটা পৰি থাকে তেনেহলে সেইটো চাবলগীয়া হয় কোনো ক্ষেত্ৰত। ঠিক আছে, গতিকে আলটিমেটলি আমি চাবলৈ গ'লে supervisory jurisdiction টো আৰু বহুত ব্ৰডাৰ, কাৰণ ইয়াতে গোটেইখিনি ফাংচনছ পৰে, নিজৰ অৰিজিনেল জুৰিসডিকশ্যন পৰে, এপেলেট পৰে, তাৰ উপৰি কোনোবা মানুহে বা কোনোবা অথৰিটিয়ে যদি if any party if any party or if any authority has not approached the high court and the case is still pending in the subordinate courts, then the high court itself can ask the subordinate court to transfer the case to the high court. গতিকে ultimately চাবলৈ গ'লে the power of superintendents of high court is very broad, and moreover it covers not only administrative superintendents but also judicial superintendents. Okay, it is a revisional jurisdiction because it can be suo moto. Suo moto means to do something on its own. Jitu moi just kolu suo moto appeal nokorakeও high court e nije supervise kori pelai jodi dekhise je it should be this case must be settled by the high court because it is taking too long duration of time, then it can do so. Gotike suo moto and not necessarily on the application of any party. Gotike through suo moto the high court can handle cases or the ask the subordinate courts to transfer the case to the high court. Gotike ei kotha kinir karone mane the power of superintendents of high court is very broad. Okay, and this power does not vest the high court with any unlimited authority over the subordinate courts and tribunals. Actually, it is an extraordinary power. Okay, and to be used most sparingly and only in appropriate cases. Usually, it is limited to excess of jurisdiction, gross violation of natural justice, error of law, disregard to the law of superior courts. Okay, then this is control over another jurisdiction is control over subordinate courts. See, in addition to the appellate and supervisory jurisdiction, a high court has administrative control and
sorry, Nimnita, just a
Yes.
request to the students not to use the annotate, please. This is the pointers, your request to the students. Please just listen to the lectures because your faculty member gets disturbed and others too. Please do not use the annotate. Thank you. Please proceed, Nimnita, please.
okay. See, in addition to its appellate jurisdiction and supervisory jurisdiction over the subordinate courts, which we have already discussed, it has administrative control and other powers over them. See, it is consulted by the governor in matters of appointment, posting and promotion of district judges. গতিকে আমি এতিয়ালৈকে যিখিনি পঢ়িলো অৰিজিনেল জুৰিসডিকশ্যনত কেনেকুৱা ধৰণৰ মেটাৰ্স আহে বা এপেলেট জুৰিসডিকশ্যনত কি থাকে, supervisory jurisdiction high courter মানে functions কেনেকুৱা থাকে. So now we are discussing about control over subordinate courts. তাৰ মানে Appellate means apart from appellate jurisdiction, supervisory jurisdiction over the subordinate courts. The High Court also enjoys administrative control. It has, some powers. It has some functions regarding the administrative system of a particular state or some states. Okay, so it is, consulted by the governor in matters of appointment, posting, and promotion of district judges, and in the appointments of persons to the judicial service of the state. গতিকে এইবোৰ ক্ষেত্ৰত গভৰ্ণৰে কি কৰে? The governor consults with the high court. That is, the governor consults with the chief justice or the judges of the high court. Okay, তাৰ মানে district judge বিলাকৰ ক্ষেত্ৰত যে regarding the appointment, posting, promotion, so of the district judges, আৰু judicial service ত অকল যে judge থাকে হেতু নহয়. I think you all know the judicial service ত বেলেগ বেলেগ পোষ্টত বেলেগ বেলেগ মানুহ থাকে. Okay, so গতিকে সেই গোটেই বস্তুবোৰ যেহেতু গভৰ্ণৰে কৰে, appointments hawk, promotions hawk, transfers hawk. So this all these are done by the governor, and the governor sometimes consults with the high courts. Okay, chief justice hawk but judges of high court hawk, sometimes the governor consults. So you say ami ei khetrot koba paru je high court or state administration to কিছু কিছু ক্ষেত্ৰত role আছে, কাৰণ যেহেতু state administration tour judicial sector to যেহেতু high court or judge বা high court or chief consult কৰি হে কামখিনি কৰা যায়. So we can see that high court has some administrative control also, isn't it? And the high court deals with the matters of posting, promotion, grant of leave of the members of judicial service of the state, other than the district judges. যেটো মই কৈছো যে judicial service ত অকল judges যে থাকে হেতু নহয়, judicial service ত থাকা যিকোনো পোষ্টৰ যিকোনো মানুহৰ এই গোটেই কামখিনি গভৰ্ণৰে কৰি দিয়ে with due consultation with the high court. And moreover, the high court can withdraw a case pending in a subordinate court if it involves a substantial question of law that require the interpretation of the constitution. So it can either dispose of the case itself or determine the question of law and return the case to the subordinate court with its judgment. যেটো অলপ আগত মই কলো যে নিজৰ মৰ্জি মতে subordinate court order দিব পাৰে to transfer the case to the high court. তাৰ পিছত কিন্তু যদি দেখিছে যে it can be solved, actually it is a matter which can be solved by the district court also, then it can give orders to the subordinate courts to solve the issue within a given time period. And its law is binding. Its law is binding on all subordinate courts. Means the subordinate courts will have to abide by the law of the high court. So its law is binding on all subordinate courts functioning within its territorial jurisdiction. In the same sense as the law declared by the Supreme Court is binding on all courts in India. Okay, Supreme Court Supreme Court or law, Supreme Court যেটো order দিব law হেতু যেনেকে it is binding on all courts in India, ঠিক তেনে ধৰণে high court the law of the high court is binding on all subordinate courts. High court যেটো order দিব, যেটো law order দিব subordinate courts বিলাকক, they will have to abide by that. Okay, in any case they cannot question. And then the sixth one is the court of record. See, as a court of record, a high court has two powers. Number one is the judgments, proceedings, and acts of the high courts are recorded for perpetual memory and testimony. The records are actually admitted to be of evidentiary value and cannot be questioned when produced before any subordinate court. They are recognized as legal precedents and legal references. And number two is, you see, it has power to punish for contempt of court either with simple imprisonment or with fine or with both. I think etu to buji paise aru mane punish koribo para jay either with simple imprisonment mane imprisoner dibo pare or with fine or with both. তাৰমানে কেতিয়াবা I think you have heard যে কেতিয়াবা ফাইন ভৰিয়ে the case gets dismissed, কেতিয়াবা imprison হয় বা কেতিয়াবা দুইটা হয় আৰু এই দুইটা পাৱাৰে হৈছে these two powers fall under this jurisdiction, a court of record. ঠিক আছে, that means the records of the high court are admitted to be of evidentiary value and cannot be questioned, okay, on when produced before any subordinate court. The last one is power of judicial review. So now you have to know that judicial review mane ki. The judicial review means to examine the constitutionality of legislative enactments. We all know that we have in our country we have a number of legislative enactments. হয় নহয় যে legislative enactments মানে যিবোৰ আমাৰ acts আছে, যিবোৰ legislative acts আছে, হয় নহয় they become acts after getting enactment, isn't it? So judicial review mane hoise, you know, this is a power, this is a process. Okay, this is a process to you know, examine the constitutionality of legislative enactments and executive orders of both central and state governments. Tamane judicial review mane ki he legislative enactments bur je ase ketiaba কোনো কোনো ক্ষেত্ৰত এনেকুৱা হয় যে হেখন এখন particular act হিচাপে implement হৈ গল, কিন্তু act হিচাপে implement হৈ যোৱাৰ পিছত it does not mean that the act will get implemented for lifelong. যদি দেখা গৈছে যে এখন why a particular act has been made. You see, this is a important question, that why there are legislative enactments. The answer is that when we see that in certain circumstances, in certain situations, or according to the need of the hour, when we see that we need some legislative enactments over a particular issue, then legislative enactments are made. Just take it as an example, jeneke iti ami koi asu je mob lynching act ekhon lage. So mob lynching act ekhon lage boli je koi asu, why people are now, you know, raising demands to have a mob lynching act? Because we are witnessing a number of mob lynching incidents. হয় না নহয় আমি এটা যেটো present পরিস্থিতি দেখি আছো, we have witnessed you know, a number of mob lynching incidents either in Assam or in any other part of India. So that is why hoyto kaile porohile jeneke domestic violence act ahile, because the domestic violence mohilar report hoye ase heto bahut dekha goise, to prevent that domestic violence act kon ahile, hoy na noy. So thik tenedore hoyto kaile porohile mob lynching act kon ahibo. Kintu judicial review mane ki eto mane moi just example hisabe disu, if you have read the Prevention of Domestic Violence Act, you will get to know যে কিছু কিছু ক্ষেত্ৰত এক্স খনৰ বহুত loopholes আছে. There are many loopholes, okay, and hey loopholes bilak basically the male section of the society ইহতি প্ৰায় সেই loopholes বোৰ উলিয়াই লাহে লাহে আহি আছে যে এইবোৰ loopholes এক্ট খনত থাকাৰ কাৰণে you know, not all, I'm not generalizing, but not all, but you know, some of the women are taking advantage out of the act. কিছুমান loopholes থাকা কাৰণে, not the whole বুলি কোৱা নাই, কিন্তু কিছুমান ক্ষেত্ৰত কিছুমান মানে articles provisions ৰ কাৰণে সেই act খন মানে সুবিধা লোৱা গৈছে কিছু মহিলাৰ দ্বাৰা, গতিকে হেতু কাৰণে some women are taking advantage, actually they are taking disadvantage of this domestic violence act. So that is why a act খন মানে reform কৰিব লাগে বুলিও মানে কথা শুনা যায় আৰু if you want to read you can Google it also. গতিকে সেই বস্তুটো মই জাস্ট এক্সাম্পল হিচাপে দিছো, যেটো যে কলো যে জুডিচিয়েল ৰিভিউ, তাৰমানে সেইখন এখন লেজিসলেটিভ এক্ট, হয় নে নহয়, সেইখন এখন এক্ট বনা গল and the act has got implementation also, isn't it? কিন্তু যদি কেতিয়াবা এনেকুৱা হৈ যায় যে বেসিকে with you know with valid points, with strong valid points, if we see that domestic violence act is also against men. Are you getting the point? Jodi italeke hua nai, okay, don't take it je eto holei buli, italeke hua nai, kintu jodi ketaba dekha jay je you know act khone the act has become a source of violence against men also, tetia kintu he through judicial review, by examining the constitutionality of legislative enactments, judicial review mane hetue je tetia examine kori pelai jodi dekha jay tenehole kintu he এক্টখন দৰকাৰ পৰিলে কেতিয়াবা উঠিও যাব পাৰে গতিকে জুডিশিয়াল ৰিভিউ মানে হৈছে হেতু যে ইট এক্সামাইন্স কনস্টিটিউশনালি কিমান আছে constitutionality of legislative enactments and executive orders also of both central and state government executive order which are given by the central and state governments that executive orders can also be suspended at a particular point of time okay that hey order to hey homoyot hoito there is constitutionality okay hey homoyot hoito that order has to be given and that order contained constitutionality ha কিন্তু পিছত যদি আকৌ এবাৰ সোৱা যায় যে জুডিশিয়াল ৰিভিউ কৰি পেলাই যদি সেইখন ইমপ্লিমেন্ট হল বুলিয়ে যে ফৰ লাইফ লং হ'ব যেহেতু তেনেকুৱা কথা নহয় পিছত যদি আকৌ এক্সামাইন কৰি সোৱা যায় আৰু তেতিয়া যদি দেখা যায় যে it does not contain actually does not contain constitutionality then then that order or then that enactment can be suspended এইটোৱে হৈছে power of judicial review গতিকে আৰু এতিয়ালৈকে কনস্টিটিউশনাল এমেন্ডমেন্ট এক্ট 100 নে এনেকুৱা দুখন মান আৰু এখন আছিলে নেশনাল জুডিশিয়াল এণ্ড এপইন্টমেন্ট কমিশন নে এনেকুৱা আছিলে এই দুখন বস্তু দুখন লেজিসলেটিভ ইনেক্টমেন্ট এতিয়া কিন্তু সাসপেন্ড কৰি দিয়া গৈছে কাৰণ কি প্ৰথমতে লেজিসলেটিভ ইনেক্টমেন্ট হিচাপে বনিলে কিন্তু তাৰ পিছতে তাক এক্সামাইন কৰোতে that there is no deep constitutionality okay যদিও হেতু সময়ত পাস কৰিছিলে মেবি according to the need of the hour লাগা হৈছিলে বা হেতু সিচুৱেশনত হয়তো লাগিছিলে যে এতিয়ালৈকে যিখিনি প্ৰভিজনছ আছে the provisions contain constitutionality কিন্তু পিছত এক্সামাইন কৰি চাওঁতে যেহেতু একো constitutionality দেখা যোৱা নাই গতিকে তেতিয়া কিন্তু হেতু invalid বুলি পেলাই সাসপেন্ড কৰি দিয়া গৈছিল so that is the power of judicial review So regarding to High Court topic to report, I think I have touched all the areas regarding the organization, regarding the qualification. Organization বুলি ক'বলৈ যাওঁতে High Court কোন কোন থাকে, qualifications কি হ'ব লাগে, বা tenure কেনেকুৱা হ'ব বা কি কি ক্ষেত্ৰত remove কৰিব পৰা যাব judges বিলাকক by the president. And then High Court jurisdiction, powers and functions কেনে ধৰণৰ এই সাতটা ভাগত ভাগ কৰোৱা যায় আৰু তাৰ মাজত কি পৰে এইটো more or less we have discussed in brief isn't it so I would like to receive queries if there is any query আৰু যদি High Courtৰ ওপৰত কিবা লাগে if you want then also you can ask me in the last class also some of you asked me to give the articles related to the governor which are important which I have given in this class গতিকে High Courtৰ ক্ষেত্ৰত যদি আৰু কিবা questions বা queries আছে then they will be welcomed so please interact and in this two class we have completed CM the governor and the High Court okay so these three topics are completed I have touched so far I can all the areas of these three topics
ma'am there is
yes.
a message from Mitali in chat
yes what's the message yes
okay so the message is from Mitali. She is asking that ma'am articles important regarding High Court and the another one was from how many High Court judges have been removed so far
see regarding the topic High Court you don't have to remember much of the articles okay basically organization কেনেকুৱা qualification কি এইখিনি more or less আহি থাকে গতিকে যি ধৰণে মই গভৰ্ণৰৰ দিছো আৰ্টিকলছ বা CMৰ মনত ৰাখিব দিছো তো High Courtৰ তেনেকুৱা ইমানকে বেছি একদম বহুত ইম্পৰ্টেন্ট বুলি ক'বলৈ কাৰণে তেনেকুৱা আৰ্টিকল মনত ৰাখিবৰ কাৰণে for your exam তেনেকুৱা ইমান বিশেষ নাই কিন্তু যদিও নাই I think you have remembered যে মই jurisdiction পঢ়াই থাকোতে I have asked to remember this article, that is Article 226 of the Constitution empowers the High Court to issue writs. Okay, this article is very important. Aru logote Supreme Court I mention korisu, that is Article 32. গতিকে হাই কোৰ্টৰ ক্ষেত্ৰত ইমান বেছি একো নাই তেনেকে আৰ্টিকেল ৰাখিবলৈ কিন্তু এই ৰিট জুৰিছডিকচনৰ এই আৰ্টিকেল 226 is very much important.
Okay, ma'am.
Ma'am,
Yeah,
Ma'am,
yeah.
I have a question.
ma'am, the first slide you can take all the articles. They are important to remember.
Yes, because apart from these 5 articles, there are many more articles. Okay, but since these are all very much important, and I have seen previous years APSC question papers, tate kisuman kotha ahise je appointment of governor kuntu article hoy ba power to grant pardon jeneke amar president of India ase aru hetu governor ro ase gotike hetu bostu confuse koribole karneo di dia hoy je grant pardon যিটো পাৱাৰ হেতু গভৰ্ণৰৰ কোনটো বা প্ৰেসিডেন্টৰ কোনটো যেহেতু দুইজনৰে সেম পাৱাৰ গতিকে হেতু কাৰণে মই দি দিছো 5টা মান মনত ৰাখিবলৈ বেছি নহয়.
Okay, aunty.
Excuse me, ma'am.
Yes,
Ma'am, read petition file কৰিলে কি judicial review হ'ব পাৰে? By way of read petition, can judicial review be done?
actually I'm not understanding your question. তাৰ মানে যিটো ৰিড
Public
আকৌ
যেনেকে
ক'ব নেকি?
হাই কোৰ্টে suo moto judicial review কৰিব পাৰে বা কিবা কেছত যদি পাব্লিকে ভাবে যে এটো কনস্টিটিউশনালি কিবা এক্ট পাস হৈছে এইটো আনকনস্টিটিউশনাল তো ৰিট পেটিশন কিবা ফাইল কৰি কিনে এটো কোৰ্টক বাধ্য কৰাব পাৰে নেকি জুডিশিয়াল ৰিভিউ কৰাৰ কাৰণে?
নোৱাৰে কাৰণ জুডিশিয়াল ৰিভিউটো এই বস্তুটো টোটালি ইট ইজ দি পাৱাৰ অফ দ্য কোৰ্ট অফ দি পাৱাৰ অফ দ্য জুডিশিয়াৰী আৰু
মানে এইটো
আনহাতে
suo moto হ'ব ন?
আৰু আনহাতে যিটো তুমি ৰিট জুৰিছডিকচনৰ কথা কৈছা সেইটো পাব্লিকে পাৰে
মানে ৰিট
ঠিক আছে
জুৰিডিকশনটো মানে জুডিশিয়াল ৰিভিউ কাৰণে কৰিব নোৱাৰে। এতিয়া ধৰি লওক চিম্পলি কোনোবা এটা মানুহে কিবা এটা এক্ট পাস হোৱাৰ কাৰণে এইটো মানে ফান্ডামেন্টাল ৰাইট ঠিক আছে বাৰু এইটো ৰুট পেটিশন বা যিকোনো কেছটো মানে আনকনস্টিটিউশনাল লাগে কোনোবা এক্ট সেইটো কাৰণে কি কৰিব পাৰে?
সেয়াই যিটো তুমি কৈ আছা যে কিবা এটা এক্ট যদি আনকনস্টিটিউশনাল যেন লাগিছে তেনেহলে সেই বস্তুটো মানে সাসপেন্ড কৰিবলৈ কাৰণে হেতু অকল হাই কোৰ্টৰ হে পাৱাৰ ঠিক আছে কিন্তু
জুডিশিয়াল ৰিভিউত নপৰে নেকি?
let me complete my point. কিন্তু ৰিট জুৰিছডিকচনৰ কথাটো যিটো আমি কৈ আছো যে এইটো ক্ষেত্ৰত ৰিট জুৰিছডিকচন তোমাৰ যিকোনো ক্ষেত্ৰতে নোৱাৰে যিটো মই অলৰেডি কৈছো যে অনলি ফৰ দি এনফোৰ্সমেন্ট অফ ফান্ডামেন্টাল ৰাইট ঠিক আছে সুপ্ৰিম কোৰ্টৰ ক্ষেত্ৰত অকল ফান্ডামেন্টাল ৰাইট যদি ভাইলেট হৈছে তেনেহলেহে পাৰে গতিকে যিকোনো এখন পাৰ্টিকুলাৰ আইন এখন বা যিকোনো এখন এক্ট এখন সেই এক্টখন তোমাৰ ফান্ডামেন্টাল ৰাইটত নপৰিবওতো পাৰে
বেলেগ কেছও হ'ব পাৰে।
Ma'am, may I intervene, ma'am? Just a second, ma'am. Ma'am, it can be done with the help of a review petition, okay? And judicial review is totally the power of the judge. Judge's
yes,
discretion.
exactly.
Judge's
It is the
discretion.
power of the judiciary, not the public. Okay.
For example, if a particular person let's suppose one act is there and somebody feels this is not correct, he cannot ask for the judicial review. He can file a writ petition to review the constitutionality of the act, not to force the judge to do the judicial review. No, judge will not do that. Judge will only do the judicial review when
he can suggest for a review of the act, no, by petition.
Yeah, exactly.
গতিকে সেই বস্তুটো যেটো মই ইস্যু অফ দ্য ৰিটছৰ কথা কৈ আছো গতিকে ইয়াতে কিন্তু ফৰ দি এনফোৰ্সমেন্ট অফ ফান্ডামেন্টাল ৰাইটস গতিকে যেতিয়া ৰিটটো ইস্যু কৰিব তেতিয়া কিন্তু সেই বস্তুটো দ্যাট শুড বি ৰিলেটেড টু ফান্ডামেন্টাল ৰাইটস ওকে এনে যিকোনো ক্ষেত্ৰত যেটো মই কলো যে যিকোনো ক্ষেত্ৰতে ৰিট পেটিশনটো দিব নোৱাৰে একাৰণে দিব নোৱাৰে কাৰণ সুপ্ৰিম কোৰ্টৰ ক্ষেত্ৰত অনলি ফৰ দি এনফোৰ্সমেন্ট অফ ফান্ডামেন্টাল ৰাইট হাই কোৰ্টছৰ ক্ষেত্ৰতহে for the enforcement of fundamental right as well as ordinary legal right গতিকে সেই যিটো মানে ৰিট পেটিশনৰ কথা কৈ আছে সেইটো বস্তু যদি ৰিলেটেড টু ফাণ্ডামেণ্টেল ৰাইট এণ্ড লিগেল ৰাইট হয় তেনেহলেহে পাৰিব কিন্তু সেইটোও আকৌ আপোনাৰ ডিপেণ্ড কৰিব যে কোনটো কোৰ্টত আপুনি এপ্ৰচ কৰি আছে যদি সুপ্ৰিম কোৰ্ট হয় তেনেহলেতো কোনো কথাই নাই নোৱাৰে বিকজ মানে লিগেল ৰাইটৰ ক্ষেত্ৰতো অকল হাইকোৰ্টতহে হয় নট ইন দ্য সুপ্ৰিম কোৰ্ট
মানে এইটো ভায়া হাইকোৰ্ট যাব লাগিব যদি হাইকোৰ্ট ছেটিছফাইড নহয় তেতিয়াহে আপিল কৰিব পাৰিব ন সুপ্ৰিম কোৰ্টত সেইটো হ'ব পাৰে ন
সেইটোতো হ'ব পাৰে সেইটো এটা ডিফাৰেণ্ট মেটাৰ যে ইফ ইউ আৰ ডিছছেটিছফাইড উইথ দ্য সুপ্ৰিম কোৰ্ট চৰি উইথ দ্য হাই কোৰ্ট দেন ইউ কেন এপ্ৰচ দ্য সুপ্ৰিম কোৰ্ট কিন্তু সেই সুপ্ৰিম কোৰ্টত যে এপ্ৰচ কৰিব হা সেই বস্তুটো কিন্তু যদি লিগেল ৰাইটৰ ক্ষেত্ৰত হয় তেনেহলে নোৱাৰে
ওকে থ্যাংক ইউ মেম
ওকে যদি সেইটো ফাণ্ডামেণ্টেল ৰাইটৰ ক্ষেত্ৰত হয় ফাণ্ডামেণ্টেল ৰাইটৰ লগত ৰিলেটেড আছে তেনেহলেহে সেইটো কৰিব পৰা যাব সেইকাৰণে মই এই পইণ্টটো কওঁতে মই দুইটাৰে ডিফাৰেন্সটো কৈ দিছো যে হাইকোৰ্টৰ ক্ষেত্ৰত দুইটা হ'ব লিগেল ৰাইট যদি এনফৰ্চ কৰিব লগা হৈছে সেই এৰিয়াটোত পৰিছে তেনেহলেও হ'ব আৰু যদি ফাণ্ডামেণ্টেল ৰাইটৰ এৰিয়াটোত এনফৰ্চ কৰিবলগীয়া কিবা ৰিলেটেড হৈ আছে তেনেহলেও হ'ব কিন্তু সুপ্ৰিম কোৰ্টৰ ক্ষেত্ৰত কিন্তু অকল মানে ৰিলেটেড টু ফাণ্ডামেণ্টেল ৰাইটছ হ'ব লাগিব বেচিকেলি এই বস্তু কিটা কৰোঁতে টু ইছ্যু ৰিটছ
ওকে মেম থ্যাংক ইউ
ৰিটছ
মেম
কিটা অকল সেই ক্ষেত্ৰতহে ইছ্যু হ'ব ওকে
Okay, ma'am, there is another question. The question I will be reading out. The question is, how many High Court judges have been removed so far and what are their names?
No, this is out of my knowledge কারণ কেইজনক ৰিমুভ কৰা হৈছে এইটো এটা এই ডাটাটো মোৰ লগত at present নাই you can google it also
And
এইটো মানে
again,
particular numberটো নাই
okay, ma'am. Again, there is a question. In case of death sentence, who has more powers? It is SC or HA?
obviously supreme court okay this is obviously supreme court কিন্তু কথাটো এইটো হৈছে যে চোৱা যেনেকে আমাৰ চেন্টাৰ আছে আমাৰ ষ্টেট আছে চেন্ট্ৰেলে you know তোমাৰ কি বুলি কম এতিয়া যেনেকে সুপ্ৰিম কোৰ্টখন আছে তেনেকে ডিষ্ট্ৰিক্টৰ ক্ষেত্ৰত বা ষ্টেট এডমিনিষ্ট্ৰেশ্যনৰ ক্ষেত্ৰত এখন কোৰ্ট দিয়া আছে হয় কি নহয় তো তেনেকে বা ষ্টেট এডমিনিষ্ট্ৰেশ্যনৰ ক্ষেত্ৰত হেড অফ দ্য ষ্টেট এজন মুৰব্বী হিচাপে দিয়া হৈছে দ্যাট ইজ দ্য গভৰ্ণৰ বা চেণ্ট্ৰেল ক্ষেত্ৰত প্ৰেচিডেণ্ট কিন্তু এইটো গতিকে তুমি যিটো কুৱেশ্যন কৰিলা যে ডেথ চেণ্টেন্সৰ ক্ষেত্ৰত কাৰ পাৱাৰটো বেছি অবভিয়াছলি সুপ্ৰিম কোৰ্টৰ সুপ্ৰিম কাৰণ কি যেতিয়া মানুহ ডিছেটিছফাইড হয় তেতিয়াইতো সুপ্ৰিম কোৰ্টত যায় ডিষ্ট্ৰিক্ট কোৰ্টৰ পিছত মই যে একদম মই ফাৰ্ষ্ট চেণ্টেন্সতে মই কৈছিলো যে হায়াৰকি অফ কোৰ্টছ আছে তো তাৰ মিনিংটো কি যে তুমি যেতিয়া সাবঅৰ্ডিনেট কোৰ্টত তুমি ডিছেটিছফাই হবা দেন ইউ উইল মুভ টু হাই কোৰ্ট হয় নাই সেই বস্তুটোকে ক'ত পৰিব এপেলেট জুৰিছডিকশ্যনত পৰিব হয় নে নহয় তো তুমি বাই চান্স তুমি হলা দেন অবভিয়াছলি ইউ উইল মুভ টু সুপ্ৰিম কোৰ্ট তো এইটো এটা হায়াৰকি হয় নে নহয় গতিকে অবভিয়াছলি ডেথ চেণ্টেন্সৰ ক্ষেত্ৰত হাই কোৰ্টে যদি দিলে অবভিয়াছলি সেই মানুহজনে সুপ্ৰিম কোৰ্টত দিব আৰু সুপ্ৰিম কোৰ্টৰ জাজমেণ্টটোৱে ফাইনেল হ'ব আৰু তাৰপিছতো যদি তেওঁ ইফ হি ইজ ডিছেটিছফাইড তেনেহ'লে তেওঁ প্ৰেচিডেণ্টক ক'ব আৰু প্ৰেচিডেণ্টে যিটো ক'ব দেট উইল বি দি আল্টিমেট দেট ইজ দি পাৱাৰ টু গ্ৰাণ্ট পাৰ্ডন য়েছ ইজ ইট ক্লিয়াৰ
Class, if you have any queries, you can ask, ma'am.